Your numbnuts. Oh, let's see here. So greetings, everybody, so far. I hope I can keep up with the
Greetings, brother.
Recording and all the information and hands up and everything. But we got a bit of material to go over, so it's going to be a while, and we'll take breaks, and we're going to find out some information. Malika and a lot of us have been talking a lot lately about the 1 USC 1, words denoting numbers, gender, and so forth. So we're going to talk about the plain writing in a lot of these codes and stuff. And I'm going to show you some things that tells us who can be what, or who can do what. So we're going to hang out for a few minutes and get some people in here. And hopefully it says admit. There we go. I just got to make sure I'm staying on top of all of this. Let's see. Share screen. We are recording. And if I click this live on Facebook, does it take me to Facebook? Let's see. They want admission to create and manage content on my page. I don't know if I want to do that. So we'll see. In the meantime, I'm going to copy this invite and share it some more. If you guys would do the same. And then we'll get started here shortly. Okay. Well, there's that for now. So we got 4 of us in. And since we're the important ones, we're going to go ahead and get started. It's being recorded, so those that are late can rewatch it. sure I'm on the right page here. And as opposed said is who can do what? The who can do what? The who can do what? And this is in Title 22, Foreign Relations and Intercourse. Persons entitled to passport. No passport shall be granted or issued to or verified for any other persons than those owing allegiance, whether citizens or not, to the United States. What is allegiance? Allegiance in their WEX U.S. law, when we look up allegiance, it actually says oath. It comes up with oath, and it says an oath is a public pledge that a person will perform some action or duty, generally with the promise of doing so truthfully. So anytime we bring an error on the record to light and give them knowledge, and they now have a true fact before them, and they don't operate on it, they have violated their oath immediately. I don't care if it's due to cognitive dissonance, negligence, not knowing but want to screw you anyway, diligent intent. I don't care what it is. It's a violation of oath. This is the key of knowledge. An oath can also be used as a way of promising oneself to support a cause or an entity. Oaths are often done in the name of a deity, like swearing under God, though this is not always the case. Today's oaths are required in many circumstances in the legal system. A person must make an oath. Again, I refer to 1 U.S.C. 1. A person, all persons, and any person, meaning every person, must make an oath or affirmation that they will testify truthfully, also called a witness oath. This is the thing about this person. A witness oath is something that witnesses it firsthand, substantially and concretely. The first person, second person, and third person is a written statement under that oath. A man can witness in oath without having to write a statement in person. Okay, there's the difference. This oath usually includes raising a person's hand and promising that the person will tell the truth, the whole truth, and nothing but the truth. This is often accompanied by placing a hand on a religious text. An example of this oath for Minnesota no-fault arbitration proceeding can be found here. Failure to tell the truth after swearing to do so, if done knowingly, results in the crime of perjury. We are told in the various scriptures that they want us to put our hand on religious scriptures, religious text, and take an oath. We are told in those various scriptures we're not supposed to swear an oath. By taking an oath to this state or anything else, we have given up the oath that he already swore unto himself, because there was no greater that he could swear to. So the oath that is already there is a promise that he gave unto Abraham, the same immutable promise that we have, so long as we follow by accepting his oath that he already gave. An example of this oath, those who wish to become naturalized citizens of a country are required to take an oath of allegiance or oath of citizenship. Those who wish to become naturalized citizens In other words, give up what is already natural and become a citizen of a country, are required to take an oath. Jeremiah 1 verse 5, we are sanctified and ordained as prophets unto the nations. If we give up that sanctification, that ordinance, and fall asunder to their sanctions of their commercial ordinances, of their oath to that commercial realm, then we have forsaken him. We have denied him, and he will then turn around and deny us. We cannot seek equity in that realm. The only place we can have equity is bringing equity, and that is only done with his word. You cannot add on to it or take away from it. In the United States, this is governed by 8 U.S.C. 1448. Before we get to that, let's check out the no-fault arbitration proceedings. Witness oath, American Arbitration Association. Do you swear, affirm that the testimony you are about to give in this arbitration is the truth, the whole truth, and nothing but the truth? What we've done here in this arbitration is we brought in a third party without recognizing the indispensable third party, our Father, which art in heaven. That is the oath that we are to witness. This is all commercial. This is just a commercial oath. And that's why they bring in another third party as a commercial entity that in arbitration, however it ends up, those arbitrators are going to get paid too. Now what you've done is enacted another trust, period. It says, which states that all applicants shall be granted or issued to or verified for any other persons than those owing allegiance. You have to apply for that allegiance. You have to apply to be able to take that oath and see if you have that same God or same religious scripture. Must promise to uphold and support the Constitution, renounce any connection to a foreign entity, and swear allegiance to and defend the United States. Not your fellow brother, not your neighbor, not your wandering sojourner, your weary traveler, but the United States, a corporate fiction. And that's in their naturalization. They're talking right here. Arbitration, American Arbitration Association, witness oath for naturalization oath. Citizens. Because now you're in communication with them instead of with our Father which art in heaven. Your communication is of their codes and statutes and stuff. Some professions also require that those entering it swear an oath. Those professional oaths usually promise that the person will perform their duties honestly, safely, and with integrity. That integrity is the accuracy. So if there's an error on the record and you point it out to them, they say, well, no, I'm just doing my job. They're renouncing their own integrity. They're proving they don't have their own individual integrity. They're proving their incompetence, their cognitive dissonance, their ignorance. For example, healthcare professionals are required to take the Hippocratic Oath. Not just doctors, healthcare professionals. If you're going to sit there and profess that you're going to be doing medical transcripts at home via a third party, and that's your profession, you better be taking that Hippocratic Oath under this. Right here. You better show your allegiance to the United States and the laws that are formed thereunder that you're following. You have to take that oath at the upper level. I don't care if you're a municipality. I don't care if you're washing cars. You're an employee by application. And you will affirm and testify truthfully in the court that you gave them that information. Yeah, I was born on August 20th. That's false. They asked you for your birth date. Your birth date was some day after you were born. They asked you for your name. It's not your name. It's the name of a person that operates in your character. And they're destroying your good name. Generally, there are no actual punishments attached for breaking a professional oath itself. However, actions that are not in accordance with the professional oath can often constitute malpractice and can lead to lawsuits or even removal from the profession. And as we discussed yesterday in the Malika Zoom on Tuesdays, you can only sue them in a personal capacity. So you have to admit to a person of the same like kind in order to be able to sue them. You have to be in that commercial capacity to be able to do that. You can't do that. You have to take that oath. You can't do that. As soon as you do that, you deny his oath. The only way you can go after your neighbor is in private. It's the only way. All individuals who are elected or appointed to public office are required to take an oath of office. This is one of those distinctions I'd like to make, is that I've been talking about this here lately, is that elected or appointed does not mean assigned. Elected or appointed is a contractual term. It's either an implied contract, an adhesion contract, or something like that. But the public office is one of trust, and the only way you can indenture that office is by an assignment. Otherwise, they operate generally under a concern of community care and nothing else. For the President of the United States, this is governed by Article 2, Section 1 of Clause 8 of the Constitution. For other offices, especially the U.S. House of Representatives, the Senate, and the Supreme Court, this is governed by 5 U.S. Code. Employees. Oath of office. General provisions, the Congress, President, flags and seal, government, organization, and employees. If you're not part of that government organization, you shouldn't be filling out forms such as registrations, such as hospital registrations, school registrations, motor vehicle registrations, when you know it's not a motor vehicle. All kinds of registrations that you're filing because you're the applicant and placing that information on the record. You are putting that presumption on the record. And this is how you're doing. You're doing it, and you're not even giving the oath under God but you're willing to go before the court, and I guarantee you will make that statement because they didn't force you to register your children. You voluntarily gave them that information. The next one, 28 U.S. Code 1631, transfer to cure want of jurisdiction. When they're professing all of these contracts, they have a sponsor and an indispensable party. Just like I mentioned, we are the indispensable party in all of these relations as a foreign body, not an entity. That's a personal characteristic. Transfer to cure want of jurisdiction. Again, we've been talking a lot lately about ceding jurisdiction. Failure to cede jurisdiction to the indispensable party, which is known as the United States, as we saw earlier. And that indispensable party is, in fact, what we call a sponsor for all contests. They're the ones that sponsor it and fund it. That's the public trust. That's how they acquire all of the funding, is through the public and the generation of the public operation of government and its organization, which is its employees. Every time you hear that term employee, they are considering you a civilian employed as opposed to a military who can or may be deployed. But you're all involved in the same plot, the same plan. Watch what happens. Transfer to cure want of jurisdiction, and Title 28 is judiciary and judicial procedure. So when they fail to cede jurisdiction, it's because they're doing all of this court action and failing to hold the required administrative hearing upon in which they do a judicial review. So this means that it involves the judiciary. You can't assert that you've made a judicial review in the administrative courts. This is the same thing as the police investigating the police. You have to now involve the judiciary to make the judicial discretion as to the intent and the letter of the law. You can't just keep running with the letter of your law in the administrative courts and say, yeah, we investigated, we did the judicial review, and you are subject. Can't do that. You have to hold the proper administrative hearing with the proper parties. Let me stop screen sharing here because I've got some people waiting or something. How do I find them? Participants, admit all. There we go. All right. Got them. Okay, sorry about that, guys. I'm going to go back to my screen share. Welcome the newcomers. Thank you for joining. We are discussing these administrative courts, administrative law judges passing their opinions and everything and failing to cede the jurisdiction of the United States. Their process is their first step is to have an administrative hearing for a judicial review to determine that the parties are of like kind and that they can commence a suit in the name of the United States courts, which is the state courts, district courts. They're all United States courts. And so they're failing to cede the jurisdiction under that judicial review.
Screen is black.
When a civil action is filed in a court as defined in section 610 of this title, or an appeal including a petition for review of administrative action. So when they fail this process, we are to petition the judicial courts, the judicial element, for a review. Courts defined. As used in this chapter, the word courts include the courts of appeals and district courts of the United States District Court for the District of the Canal Zone, the District of Guam, the District Court of Virgin Islands, the United States Court of Federal Claims, and the Court of International Trade. Oops, did they just mention international? Okay. June 25th, 1948, Title 2, Section 226.
Screen is black.
Okay, let's look up 2 U.S. code. That was 226. And they've deleted them. They're no longer there. So there's a discrepancy there. As to their authority, there's Title 5, Section 501. We know Section 5 is employees. Outside earned income limitation. What do you mean outside? You mean foreign and not domestic? You mean outside of your house?
We can't see, Keith.
Oh. Let me try screen share again then. Outside earned income.
All right.
And this is from courts defined. Do you see courts defined now? Maybe it's not switching my screen. Somebody? Do you see my screen? It says courts
Yeah,
defined.
no, it's still not showing, Keith.
Black.
It like came up for a minute, like when you redid it, and then it just stopped again.
Okay, so maybe when I'm switching screens, it's shutting down my screen share.
There it is.
Yeah, there it is.
Okay, so five US, and this is 5A. Outside earned income. How often do you see that? Usually you see the A after here, after the section. Limitations on outside employment. Are they employing people outside of their jurisdiction under the administration of an estate, which are subject to civil penalties because they've been plundering that estate the entire time? Term member means a senator. If you're not a member of that association, a representative in, or a delegate or resident commissioner to the Congress. Resident commissioner. When you're a resident under Title 19 U.S. Code 810, you're supposed to be qualified by an oath of office because you're supposed to be a federal, state, or municipal officer or agent. And thereby all of your actions are commissions. You're the one commissioning the commercial transactions. That's why they want your signature. The term officer or employee means any officer or employee of the government except any special government employee as defined in section 202 of Title 18. Special government employee shall mean any officer or employee of the executive or legislative branch of the United States government or any independent agency of the United States or the District of Columbia who is retained, designated, appointed, or employed to perform with or without compensation not to exceed 130 days during any period of 365 consecutive days. Does that sound like a member of the House or the Senate? That's your special government employee. Honorarium, travel expenses. Charitable organization means an organization described in section 170C of the Internal Revenue Code. Corporation trust, a community chest trust or community chest fund or foundation. Charitable contribution defined. For the purpose of this section, the term charitable contribution means a contribution gift to or for the use of a state, a possession in the United States, or any political subdivision of any of the foregoing, or the United States or the District of Columbia, but only if the contribution or gift is made exclusively for public purposes. Private purpose trusts. The public trust is obviously for public purposes. And if you're taking benefit of that, you're obviously using it only exclusively for public purposes and not your private purpose. You have to stop that. Okay. So that was that. So when we talk to transfer to cure want of jurisdiction, we have to remember all of their courts fall under the United States. There's no way they can get jurisdiction transferred through any kind of foreign trade zone of any sort without showing that they're getting compensated through a government contract somewhere, whether it be as an employee themselves, through a government employee or through a special government employee. Either way, it's an employee of some sort. They are employing a plan. And they have to give service through diplomatic channels, because each state is foreign to each state and foreign to the United States. And this is proven by their secession to the United States as a foreign entity. And then promulgated through acquisitions regulations that in order to acquisition anything for the federal government, they have to first have in place a contract with the federal government, a debt previously contracted in order to further that purpose of acquisitions at the state level. But they can only do it for federal acquisition purposes. They can't use state purposes. They've already ceded that the state purpose is concurrent with the federal purpose. This is why the state constitutions have to concur with the one federal constitution. Same with all of their state statutes. They all have to concur with the federal statutes here. They have to give diplomatic channels or diplomatic notice through the proper channels of service. They are a service corporation. The director of the Office of Special Consular Services in the Bureau of Consular Affairs, Department of State, the managing director for overseas citizen service shall perform the duties of the Secretary of State under Section 1608A4. What is Section 1608? It is service time to answer default, again, under Title 28, Judiciary. Because if they are seeking commercial substance, if they're seeking a commercial item known as a fine, fee, penalty, there is a process that they have to follow, and it is 90 days. They have to complete that transaction to prove a valid contract is in play. The debt previously contracted is valid only if they can complete it in 90 days. Organization of courts, Department of Justice, court officers and employees. You see here, they're officers of the court. They're employees of the court. District Court, Washington, D.C. District of Columbia, District Court. Jurisdiction and venue, procedure, particular proceedings. And when we see particular, it talks about private equity, declaratory judgments. Has anybody declared? Where do we see declaring judgments, declaring statements? Customs and Borders. Did you declare the items? Well, they're not commercial items. I don't have to declare them. Well, for safety and management reasons, well, we're going to talk biblical about that as well, because the body is what we're talking about, the res of the trust. And in trust, he gave man dominion over all life. And if I'm his property and I have other property that is his on my in my possession, you can't connect a personage or a character of commerce to that. So if I have a poisonous snake around my neck and we get along just fine, you can't tell me I can't take it anywhere I go. That's a violation of my nature in trust with another physical creature in nature under his sanctions and ordinances. As I see it, power to grant writ. Writs of habeas corpus may be granted by the Supreme Court, any justice thereof, the district courts, and any district or any circuit judge within their respective jurisdictions. The order of a circuit judge shall be entered into the records of the district court and the district wherein the restraint complained of is had. So not only do they have to make a judicial review, but if they want to issue a writ to grab the body of the trust that they are operating in as a public trustee, then they have to get it from the granting powers. They can't just go take it from the beneficiary. That's a violation of trust. Let me figure out where I'm at here. Okay. Service through diplomatic channels. This is where, again, the local district court, instead of sending something to you, a summons to you, they're supposed to contact the United States first and say, hey, this is the information we have. We need to verify. We need it verified. We need it verified. Is this a U.S. citizen? This is the information we have. It's third hand. The officer reported it from somebody. We need to verify it. This is the identification they gave us. This is the operation of trust. You're not supposed to make your own discretion and believe any man when they give you an identification. I fear not, for I have redeemed thee. I have called thee by name. Thou art mine. And he calls us in the name of Christ, his own son. You can call me Christ. I'll take no offense. He won't take no offense either. In fact, if you call me Christ, it will enhance my own thought, my own cognitive thought to step up to that responsibility of Christ, the Eucharist, and spread that same very word. When the clerk of the court concerned sends documents under section 1608. What's that tell you right there? Who is managing this? The clerk of the court. It's telling you it's a monetary action. Are you subject to their monetary actions at any time? The managing director for overseas service shall promptly ascertain, discern if the documents include the required copies of the notice of suit. See, when the clerk gets these documents, operating in the capacity of a United States representative of some sort, they're supposed to send that document to the United States Attorney General, not assign some local administrative law judge. They made a determination of a law without a license to practice law. They have a process. They're supposed to, the clerk is supposed to notice United States of America, the Attorney General, and the plaintiff that was named in the suit. Well, the plaintiff is the United States, unnamed, indispensable party, because it's the state court or the state under operation and construction of the laws of the United States that are conducting commercial items in those administrative courts. So before they can commence those actions, they're supposed to double check. It's a double check system with the local county attorney that's supposed to double check with the United States Attorney General. Generally. And they're supposed to ascertain the required copies of notice of suit and the summons and complaint or default judgment. So if they put out a summons and complaint and nobody shows up and they get a default judgment, they do the process again. So the first thing is, after a notice of suit and of the summons and complaint being verified and then sent to us by the United States, if we then don't appear or communicate, they can get a default judgment. So again, it's telling us we are, again, not subject to that process. It's still a matter of discretion, as it says, ascertain. If we don't give them the information to correct, then they will ascertain that their record is correct and keep going. But if we give them information that to correct a record and they turn around and ascertain otherwise, they have made, again, a legal determination without a license to practice law. So all we do is find the errors and correct them, and they can't use their discretion. It now goes to the point of law, clarification of law as to the intent and not the letter of the law. And it says, shall include the required copies and any required translations. This is the translation of the letter of the law as to the intent of the law. This is what they're failing to do. They're going by the letter of the law as far as the administrative process and negating the intent, which is to make sure first, for safety measures and insurance purposes and malpractice suits, that under their license, whether it be commercial, medical, or an attorney's license, that they are making the proper discretionary actions based upon the information. If not, he shall promptly advise the clerk of the missing items. Again, it's telling us that if they assign it to the administrative law judge, the law judge doesn't have the duty to tell them of missing items, because the law judge is taking upon the items as ascertained by the clerk court instead of being ascertained by the proper parties. Upon receiving the required copies of documents and any required translations, they're all required to be translated. The administrative law judge cannot use his own discretion. He has to have permission first, and then he can go upon that grant of permission. And that grant of permission was first based on the judicial review discerning whether they were like kind in commercial venues. The managing director for overseas citizen service, again, a commercial venue, shall promptly cause one copy of each such document and translation to be delivered to the embassy of the United States in the foreign state concerned. This is why we have to notice them in the district. The U.S. Supreme Court, Washington, D.C., District of Columbia, as the foreign state, because they're not doing their job. We're going to give them judicial notice of failure to cede. That's it. A service through diplomatic channels. If we go to the next one, this is the notice of suit or default judgment that they speak of. And this is where a notice of suit prescribed in section 1608A shall be prepared in the form that appears in the annex to this section. Title of legal proceeding, full name of the court, case, or docket number, name of foreign state. The name of a foreign state is a title. The title of a legal proceeding is the name of the case. Full name of the court, the case or docket number. They're identifying of the identity of the other party. Again, another title, or in some cases, a number, because in a trust that is titled, there can be many parties, one of which may be an obligor identified by a number in lieu of a name and address. Judicial documents are the nature of documents served. That's the nature. The only way they can serve service documents is through a judicial venue, which means commerce, commercial venue. It's the only way they can do it. Nature and purpose of the proceedings, again, nature is judicial. It must be commercial. There is one form of action. Federal Rules of Civil Procedure, rule number 2, there is one form of action. And nowhere else in any of the codes, rules of evidence, or anything do they define any other form of action. And it is a civil action. Why the foreign state has been named relief requested. If they don't name the foreign state properly, or they name the foreign state and identify it as a obligor and give a number, which is a matching item of data elements telling us that who the true obligor is, then they've again failed. Failed to secede. Failed to cede. Failed to cede to who? The one granting the foreign trade zone. The ability for them to operate at a transmitting utility with residents. Again, military terms, civilian or military, they're both military terms of commerce. The next one, never contract with the enemy. So if they're not giving notice to the grantor and causing a debt against the grantor, would that be a friend or a foe? I mean, these are things we've got to think about, people. Trying to get everybody. Just had someone come in. I hope I got them in anyway. So let's see the comments. Yes, one of the first comments, without allegiance, they see us as an enemy. So what about a circuit court? Same thing. All courts of the United States. Every court is a court of the United States. He doesn't have a court. He has a house. And we are stewards in his house, entrusted in dominion over all living things. That's all it is. That's the expression of the trust right there. All the things are the body. We are the trustee. The bodies are the property. And he is the grantor. And we get to use it. Anybody that gets to use it is a beneficiary. So even if we get to use it as a trustee in our dominion to be able to accept it freely for our use and then give it freely, that's a proper trustee position, because a trustee does not invest for his own purposes. This is what the commercial system does. These trustees are investing for their own purposes. I'm going to show you something here. I got a document trying to put together this stuff for my companion. She's retired, right? So we've got this Iowa Public Employee Retirement System where she invested in as a principal creditor. And they've got her name, and they've got this account statement here, and it says net monthly payment of $27,185.20 with a dollar sign. And it says monthly benefit payment thereafter is $715.40. Now that's telling me, before I go any further, that there's $27,185.27 coming into this account monthly. That's what it says, net monthly payment. And then it says monthly benefit payment is $715.40. So that's telling me there's $26,400 $469.80 difference. Now, this document right here, this accounting verifies a number as an adjustment, which is exactly 26,469.80, but they leave out the dollar sign. Evidence in, on, and for the record that in reason and logic, a reasonable man could question this, that it would seem that $26,649.80 just disappeared through some kind of adjustment of a number of 26,469.80. Can somebody verify this? Can somebody verify this adjustment? I have a concern about where that $26,469.80 went, because it is not accounted for here by the style. It's not accounted for. It just says net monthly payment, $27,185.20, $750.40 for net monthly benefit payment, and that there's some kind of adjustment, but it doesn't tell us where that $26,469.80 went. Now, I also have a document here in front of me. Harvard Law Review from 1888. And when we open it up, the first statement in it, and it says, it's titled, "The Right to Follow Trust Property When Confused with Other Property." It is a commonplace of textbooks and cases on trusts. And we know this is a trust instrument because it's naming her as a beneficiary. Somewhere there's a beneficiary. If the trustee converts the money or property, this is a trust instrument known as property, wherein money is being described and accounted and moved and all of this. And in this property, they converted an adjustment. They omitted something in the adjustment. And so I have right to question whether it was converted. And I'm going to do so. Okay. So anyway, make sure I got my pages in order. We have to realize in everything that we're doing, if we've given them information and got involved in their system, and we want to, quote, correct our status, what we have to do is help them correct their records. The next one I want to do, as we were talking about, let me continue on with that. I closed the screen down. We were talking about never contract with the enemy. And it says, and this, of course, is grants and agreements. Remember, we were talking about this foreign trade zone. It's a grant. And in order to be a resident, you have to be a federal, state, or municipal officer or agent. Okay. Federal awarding agencies and recipients are subject to the regulations implementing never contract with the enemy in 2 CFR Part 183. recipient under 2 CFR 200.1 means an entity usually, but not limited to non-federal entities. Usually, but not limited to non-federal entities that receive a federal award directly from a federal awarding agency. The term recipient does not include subrecipients or individuals that are beneficiaries of the award. Okay, so in that document I just showed you, what I need to find out is who is the recipient and who is the subrecipient. Because it seems to me that we're being classified as a subrecipient, and we really want to be the recipient and name a further beneficiary as a subrecipient of the sub or the monthly beneficial payment. I think that's the correction. That's that subrogation we're talking about. Somebody subrogated that recipient part. Because it wasn't the state that received an award by applying for a retirement fund. The state was already in a debt previously contracted, and Joyce herself was awarded an award. And then they turned around and named her as a subrecipient for monthly benefit payments. And I'm pretty sure that $26,469.80 is supposed to be going to her herself, with her person as a subrecipient for investments in the commercial system as a person. That's my belief anyway. And so they've done some kind of subrogation. So we're going to follow the trust res to make sure it wasn't confused. And again, remember, this is any regulation implementing are subject to the regulations, the recipients. So if Joyce was a recipient in that commercial aspect, it was still a commercial Joyce. It was still a person, not Joyce, the physical being. The physical being can never be responsible or liable in the commercial realm. They can only be held culpable by another man through a tort action. And that's public opinion of a jury of your peers. Even today's common law court is a misconstruction, and you bring in that $21 commercial element. Whereas the true common law is you're supposed to turn your cheek, let the common court decide. And the more people come across the same entity, and the more people that turn their cheek on them, this is why they have those 5-star ratings on eBay and all those different sites, and people that are shipping and stuff. They want to know how you rate them. How do you rate yourself? How do you value yourself? What is your self-esteem? I just posted on that earlier today too. So then the next one is part 2 CFR part 183 that they just mentioned. It says never contract with the enemy. It says purpose of this part. Again, grants and agreements. The purpose is a grant or agreement. It can't be anything else. This part provides guidance to federal awarding agencies that are granting and agreeing on the implementation of the never contract with the enemy requirements. They're the ones that are following 48 CFR 52.212-5, contract terms and conditions required to implement statutes or executive orders. So they're limited to contracting with themselves or those that are already in agreement with contracting with the government. Applicants applying for federal grants. If you go down to a local utility and you place your information and data elements with them to apply to have them supply you with utilities, that's what they're going to do. And they're the ones that are going to apply for the grant to make those provisions, to provide you those supplies. because you applied as a resident. They're the ones with the commercial oath. And you applied as a resident without an oath, which it's double-minded. You can't apply as a resident unless you've got an oath. And then they're the ones that have an oath, don't realize they're a resident, and don't realize that even with that oath, that doesn't mean that they have the right to subrogate or switch the credit swaps. And that's exactly what they're doing every step of the way, because they're the employee. Remember, that's a title. That's the title. Employee is the title. Statutory provisions, section 36, Trading with the Enemy Act. This is the statutory provisions in the tax code. The vesting in or transfer to the alien property custodian of any property or interest. Can the state claim property as its own? Again, in regards to the statutes and regulations, if they proclaim eminent domain on anything, they have to do it through the United States eminent domain. Contract terms and conditions required. So they have to notice them. Anytime they're trying to acquire anything from anybody for any reason. Does everybody understand that? Their first duty in all of law is giving legal notice. That legal notice must be done with notice through diplomatic channels, and it must show that they are like kind in order to get permission, grant, to follow that suit. First and foremost. Okay, I don't know where they're trying to get approved for the call, but I'm only getting them one here and there. We have 12 available now. I can check the waiting room. Where is that? Lock meeting, no. Enable waiting room, high profile. Everybody should be put in a waiting room and it should show me that they're there. And all I got to do is admit. But all right, back to the screen share here. In regards to Trading with the Enemy Act and the contracts and employees, that nice little clerk down at the store. Remember, we talked about the clerk, okay? So we go to the grocery store and that clerk hands us a receipt. By process, the commanding officer caused receipts to be given so that the spoliated owner could obtain indemnity. Spoliated owner, they're admitting that the owner was plundered. And the reason he was plundered is because we're forced to use Federal Reserve notes or obligations of the United States or other securities of the United States in order to perform all these transactions. But we're only forced to do that as beneficiaries. When we do that, we have to let them know that we're only operating as beneficiaries. And from now on, every receipt that has been caused to be issued by any commanding officer that must go through a clerk and is mistakenly handed to me, I will have to do my due diligence and give notice to the proper administrative authorities, which is the military, under 50 USC 4305, Trading with the Enemy, wherein no one shall be held accountable in any court upon full discharge and acquittance, and that is had by giving receipt for indemnification. That's it. That's how the whole system works. But they have no right to ask anything. You have to give an allegiance of oath to them. First and foremost, for any of this to be proper and valid to take place. First and foremost, a must. This is service on government officers in official capacity agencies, and this is concurrent with Rule 17. Does everybody see my screen here? Rule 17. Somebody give me a yes, no. Rule 17 tells us, I'm going to move on as if though it's a yes. Acquiescence is a yay. Plaintiff and defendant capacity, public officers, real party in interest, designation in general. They weren't actually assigned. Yes, I can hear you. It was a designation through appointment or election or employment of some kind of application that wasn't applicable to begin with. Executor, administrator, guardian, bailee, trustee of an express trust, a party with whom or in whose name a contract has been made for another's benefit. So an award was given to Joyce A. Schmidt, and as a subrecipient, Joyce A. Schmidt, the all caps, the one that was awarded it, has a contract has been made for another's benefit, made the benefit for Joyce A. Schmidt in lowercase, upper and lowercase. So now Joyce A. Schmidt, the all uppercase, has $26,469.80 collecting every month and is only paying the subrecipient the monthly benefit payment to Joyce A. Schmidt, upper and lowercase, of $715.80. A party authorized by statute. Remember, we talked about the indispensable party, which is the United States, because it is the federal acquisitions regulations that makes the contract with all states. So there's one indispensable party, and then there's another indispensable party known as the foreign body that they've made a claim against that isn't being named properly. Failure to cede to the United States and failure to cede to the equitable title holder. Because I don't care whether it's issued forth from the states or the United States. If it's got my name on it, I'm the one that is most entitled to hold it, whether it exists or not. Action in the name of the United States for another's use or benefit. One of those parties, whether it be Joyce A. Schmidt, all uppercase, or Joyce A. Schmidt, upper and lowercase, is in fact a clarified and claimed United States citizen and a state citizen under dual citizenship within the very Iowa public employee retirement system. Can't be denied. Joiner of the real party in interest, Failure to joinder the real party of interest. Rule 19. Required joinder of parties. It's required. You have to name the indispensable party in all cases, which in every case of commercial content for acquisitions must be the United States Attorney General. Must. Capacity to sue or be sued. This is the like kind. If you are going to sue them, again, if you're professing that you don't have a person, you can't then turn around and sue them. Again, why profess? Just get the receipt, return it for full acquittance and discharge. Make your qualified statement, memorandum of obligation, point out the obligation, and return it. And this is what we're doing here tonight. This is pointing out all those elements of obligation. You got it from a clerk. She is clarified as a clerk, and she claims to be a resident, an agent of a federal, state, or municipal office of some sort, commissioning a transmitting utility of commerce in a foreign trade zone, awarded a grant from the United States. Minor or incompetent person. Let me see. I don't know if I remember posting this. I have to check real quick. But we're talking about competency. And in their administration, which we recently discussed, is why is it not doing that? Okay, we'll go this one. Disability, there it is. Disability. Let me read this. This is under who may be a debtor. The requirements of paragraph 1 shall not apply with respect to a debtor whom the court determines after notice and hearing. After notice and hearing. You have to give the proper notice and hearing to the correct party. Is unable to complete those requirements because of incapacity. If I'm not a resident, I am incapacitated. I'm already disabled from their courts, okay? Disability or active military duty in a military combat zone. For the purpose of this paragraph, incapacity means the debtor is impaired by reason of mental illness or mental deficiency, so that he is incapable of realizing and making rational decisions with respect to his financial responsibilities. And disability means that the debtor is so physically impaired as to be unable, after reasonable effort, to participate in an in-person telephone or internet briefing required under paragraph 1. In-person telephone or internet briefing. Where are the courts nowadays? What just happened before your eyes, folks? Did they just tell you? Means that the debtor is so physically impaired as to be unable, after reasonable effort to participate in a in-person telephone or internet briefing. If I don't perform commercially and you can't require me to perform commercially, can you say that I'm disabled because I can't perform commercially? No, you can't. I can perform commercially if I wish, but just because I don't wish to doesn't mean I am disabled, and therefore you can just move ahead with your commercial administration. We have to rebut these people. And just because you profess that I have to do it by telephone or internet, sorry, what about the definitive paper form? Is that in person? Is that the person named in the instrument? That if I sign on under authorized representative unambiguously, then I'm not liable for? Really have to start thinking about this stuff, people. Okay, so let's go back here. Malika is the one that brought me up on this because she had a passport. Remember, we started back here with passport. Persons entitled to passport. No person shall be granted or issued. Now, what is greater, an issue or a grant? A grant. An issue is something commercial, and a grant is something given freely. Okay? So under a grant, no passport shall be granted. So if it's intended to be freely, do you really have to give it, or can you just accept the fact that you give him free passage? Isn't that what that statement says? If somebody is willing to grant a passport for certain capacities, then what is the requirement? Persons entitled. So where is the requirement? Persons entitled. I find no requirement for a passport. None. By the authorizing authority, there is no authority to require a passport. The way it works is if I am going to go from America to France, I give notice. A gentleman gives his notice, and he writes to the embassy of the United States in France and says, hey, listen, I'm not a resident. I'm not an alien. I was born on this land. I'd like to come visit in peace as a tourist. You know, I want to tour your place on a mission of our spirituality together as neighbors across the water. So why do we need a passport? To go out from the United States. Serious questions to think about, people. The next one, like I said, Malika is the one that brought me to this because of her passport issues on traveling. And I come across redress control numbers. So I'm going to drop this link in here. And there you go. It's in the chat section. So if everybody wants to pull it up, it's redress. First Amendment, freedom of association, declaring that we're sojourners and foreigners among the lands with him. We fall under the full armor of God. And you've dressed our person wrong. Get that fucking lipstick off of him. He's a man. The redress control number allows the Transportation Security Administration Transportation Security Administration, again, for safety purposes, the Transportation Highway Safety Act, all for insurance purposes. Marine insurance from the Coast Guard, inland marine insurance from the postal system, and transportation insurance from all the residents getting driver's license because they're required to. All activated through the Social Security number or the Selective Service number, both consequently acronyms SS. This stuff should be right in your face, people. Programmed to match travelers with the results of their redress case. Secure Flight is a behind-the-scenes program that streamlines the watch list matching process. Airlines have modified their reservation system as part of the Secure Flight program. This improves the travel experience for all passengers, including those who have been misidentified in the past. Requiring any kind of transportation passport is, in fact, a misidentification to begin with. They have already paid for their ticket, dumbass. They are no longer performing commercially. 1 + 1 = 1. In other words, none of your business. I already paid for my damn ticket. You don't need a passport. The ticket is the receipt issued and given by a clerk, caused by a commanding officer to issue it. Dummy. So, SF-95, Form SF-95, claim for damage, injury, or death. Please read carefully the instructions on the reverse side and supply information requested. The fallacy with this is we should extend information that is not requested because they're only asking for information for commercial purposes. That is why it is on an OMB approved form. They have to attach a commercial item to give you any kind of remedy. And if you think your remedy is a commercial item, I ask you once again to turn to the scripture. We go down to this bottom part, and it says civil penalty, penalty, civil penalty, penal meaning military, civil meaning contract, criminal penalty meaning military, criminal meaning only a military crime, military only being commercial. Period. For presenting fraudulent claim or making false statements. What I want to point out again, you gave them the information to then follow up on. You applied it. You have to accept your fault in it. It has to be a mutual agreement of fault. In so doing, professing in so doing, professing your own forgiveness for that other party. This is the fallacy of filing a suit. If you're going to file a suit and go after someone, you're not forgiving them. We have to realize we're supposed to go to our brother in private. We're supposed to use this information and give them this form to fill out against each other. Because that's in fact what they're supposed to be doing. Here you go, county clerk. Here's an SF 95 form. Because that county prosecutor, he wasn't supposed to give you that information. Oh, and here's one to the United States, because United States needs to let that clerk know that I'm the one you was supposed to give it to. Now, by accepting the information from a party that isn't competent to give it to you, and then you giving it to another party that wasn't competent to receive it, that's how that system's supposed to work. It's their system. They're the ones subject to it. They're the ones that are subject to not contracting with the enemy. They've made enemies of ourselves with each other because we're entering false information and then accusing somebody else of making false claims. You got to quit it. Yeah, the guy pulled you over and gave you a ticket. He made a valid claim in his cognitive dissonance, just the same as you made a valid claim in your cognitive dissonance of going out and applying for a MIC job for a MIC paycheck as a MIC subrecipient. Because I guarantee you that's what these employers are doing. They've taken an insurance bond and they're pulling $27,000 a month and giving you a paycheck out of it. The next one is statements or entries generally. And this is again why I say you have to agree. You entered the statements. You entered the information. I'll never do it again. I've got a statement of separation telling them I recognize it's all of this information, the name, address, and social security number. I recognize all three of those as national identification information that is of national importance of the highest degree. And I don't want to violate any espionage laws or be accused of statements or entries in generally as being misconstrued as falsified, concealed, or covered up by any trick, scheme, or device of material fact. Because I'm letting them know that it is a material fact that there is no oath on record. The two contracting parties have to have oaths to the very contracting sponsor, the one that is sponsoring their ability to contract in that venue. We all have the ability to contract without that venue in privacy. We do not have to contract in public venue, period. The next one is relating to the definitions wherein they talk about international terrorism. And again, that's why I'm not giving that information out anymore. You're never going to accuse me of international terrorism. Everything I'm putting out here is your stuff. When we go down to 5, the term domestic terrorism means activities that involve acts dangerous to human life and that are violations of the criminal laws of the United States or any state. Remember that SF-95 form. It's a penalty. It's a criminal penalty or a civil penalty, and therefore it's a military law. Do not let them confuse you. Appear to be intended to intimidate or coerce a civilian population. I'm not trying to intimidate or coerce a civilian population that is already intimidated and coerced. To influence the policy of a government by intimidation or coercion. I am not trying to intimidate or coerce anybody. I am placing in the public domain, once again, information that is in the public domain and expressing how it is plainly written to affect the conduct of a government by mass destruction, assassination, or kidnapping. I'm not involved in any of those. I purport to you, keep printing this stuff. Keep printing your documents like this. Please. Keep proving how you're inconsistent. Occur primarily within the territorial jurisdiction of the United States. Primarily. Guess what, folks? Those Social Security accounts are minor accounts that are related to the primary account known as the Treasury Direct Account, meaning it's directly related to the Treasury of the United States. Now, if anybody thinks that I'm babbling or what I'm saying isn't concise enough English and that there's so much error in it that it does not supersede what is put before you and it actually expressing a greater truth to what is put before you, then please shut my mouth. Prove that I am saying the wrong things. And the term military force does not include any person. So why, under Title 18, Crimes and Criminal Procedure, being delegated by judicial review under civil and criminal codes that are in fact statutes under contract with the federal government, hush.
I heard. Yeah, I heard him barkeep. I'm like, I'm announcing myself before I get much closer.
Designated. Where do we see that before? As any officer or agent designated. That's your appointment and assignments, or appointments and elections. Nobody's actually been assigned to the position of trustee, and they're only acting under appointment or election as designated by these codes. Immigration and nationality. And when we're talking about immigration and nationality, we're talking about the Foreign Sovereign Immunities Act. Social Security numbers. General, one of my favorite terms in Social Security Administration, maintains a record of earnings reported for each individual assigned a Social Security number. So were they elected and appointed, and under that election and appointment, supposedly were then able to assign me? I think not. Certification is false. No one made a handwritten statement of the intent of the assignment. And if anybody can bring this forward, please do so. because as far as my knowledge says, I have never been named in any trust under any proper assignment. It is only presumed as a beneficiary unnamed, which is how trusts operate. Do beneficiaries have to be named? No. Can they give a number in lieu of the name and address so that the trust is operated appropriately? Yes. So merely by them asking for name and address is a violation of the trust and their commercial oath. Period. Again, I ask anybody of any legal realm, any legal expertise, law or otherwise, estate trust, traffic citations, I don't care what area you study. Bring it to me if you think I'm wrong. I don't care if you got 8 years of college, I ain't got none. I still don't think I'm wrong in this plain writing. Tell me I'm wrong. Prove me I'm an idiot. So, each individual assigned. So who's eligible to be assigned? You means an individual who owes a debt to the United States within the scope of this subpart. What special definitions apply to this subpart? We, our, or us mean the Social Security Administration. You means an individual who owes a debt to the United States within the scope of this subpart. The only way you can owe a debt, and Malika, if you're on, please put that link in the comment section. I can't seem to find it. I know it's around this one here. Let me see if I can look it up. That was... application on an individual needing a Social Security number may apply for one by completing a prescribed da-da-da-da. So you have to need one first, okay? Get that? .104, who can be assigned a Social Security number? Persons eligible for a Social Security number assignment. We can assign you. Now, if they haven't been assigned, how can they then assign you a number if you don't owe a debt to the United States? Did you apply for a Social Security number saying that you needed one without realizing you don't need one because you don't owe a debt to the United States? Meet the evidence requirements under 422.107. General, to obtain an original Social Security number card, you must submit convincing evidence of your age, U.S. citizenship. You have to admit to being a U.S. citizen. You have to admit to have taken an oath of allegiance to the United States or being a United States citizen. It's a must. So at the state level, when they use that Social Security number or account against you and say, well, it doesn't apply to the United States. That's all they're doing. So, everybody with me yet? I'm hearing all kinds of silence, and I hope people would learn to speak up. I want some interaction here. Okay.
Are you gonna post this, Keith?
Yes, I am. Yes, I am.
I gotta kind of go over, it, digest some of the stuff. But this is my question. I understand they made up all these rules, and then I get it that we misappropriated or we erred because we never expressed the trust, never told them our intent. There's a lot of things that go with trust, but then on top of that, but they made the laws. How do they get to be the ones so far, but then we are liable for our mistakes when they the ones who make the mistakes, and people are going to jail behind some of these mistakes?
Well, and that's because a lot of people are going forth and making threats. And what we got to do is we got to let them know that there's some civil penalties that are available if they don't cede jurisdiction. We're just giving them notice that you need to cede jurisdiction. We're going to give them notice that you failed to cede jurisdiction, but we're going to be fair about it. You know, we just want to correct the record. You know, and this is supposed to be an effective and immediate estoppel, so that nobody has to come to the right of bearing arms or entering and quartering in somebody's houses without a warrant. This is really what we're talking about. Everything that they're doing needs to be it needs to be recorded in such a certain fashion that anything out of that fashion is a nullity. Complete nullity. When we talk about Title II and never contract with the enemy, it's the election of senators and representatives. And these are the people that are making the allowing for the assignment of the Social Security number without, you know, let's go back to that. Let me see here. Application. And comprehend how this works, folks. If they're assigning a number and then you're using the name in trustee capacity, which is what the presumption is, listen to when they assign the number. And remember, these are all contract statutes, meaning they're enforcing contracts that can't be contract enforced against minors. Application. If you complete a prescribed application, we will require you to furnish evidence as necessary to assist us in establishing your age, U.S. citizenship, or alien status. That's if you apply. Where a parent has requested a special or requested a Social Security number for a newborn child as part of an official birth registration process. Now, I don't know about you, and I ain't a complete idiot, but I know these days when you go into that hospital and you tell them, no, thanks, I don't want a Social Security number, they say, oh, no, you got to. It's part of the birth process. Now, listen to this. If you don't request it, it says where a parent has requested a Social Security number for a newborn child as part of an official birth registration process described in paragraph B2 of this section, the state vital statistics office will electronically transmit the request. The birth registration at the hospital is that request. It can't happen without a social security number being attached to it to assign a trustee eventually. But what happens oops, wrong one.
We're back.
See if I can find it here. Maybe I lost it. Generally, an applicant for an original or replacement social security number card may prove that he or she is a U.S. citizen by birth. So it's evidenced of U.S. citizenship at birth by applying for a social security number so that somebody will eventually apply for the social security card, telling us that U.S. citizenship is conferred at birth and the social security number is assigned at birth so that when the man turns 18 and applies for the card, it is then activated. But the presumption has already existed on the record through evidence that he was a United States citizen. This is an awful big presumption, don't you think? It's an awful big presumption that a minor at the age of 18 would all of a sudden owe the United States a debt. How does a minor come to owe the United States a debt when he can't contract until he becomes an adult? So we see that in making application to be able to contract in their venue, you're claiming you owe a debt to be able to contract. And therefore proving that you're incompetent, and therefore you actually apply for an insurance scheme. It's a Ponzi scheme. It's an insurance Ponzi scheme. So at any time you perform in transportation as a resident of a transmitting utility of a foreign trade zone granted under the United States, there's inland insurance somewhere known as transportation insurance. And any communication that you use on postal routes, whether they be bank routing numbers, the mail system, the internet, you have a person that can be held liable through that number. That's how it operates. And it's all done through that canal zone, through Coast Guard. Marine insurance converted to inland marine insurance, converted to transportation insurance, all for your safety and health, because you were already deemed incapable. You had the inability, disability at birth. You were already deemed disabled at birth. So that's it for now, folks. I'm opening the board for discussion. I'm glad to go through any of that. When I post the Zoom, I will post all the links. I will try to find out how to get all the chat comments and post them as well. See here. Save chat. Show in folder. Got it. So the chat is saved as of now, folks. I hope everybody enjoyed the information. And please, I need to open the board. I need your help too. I need your voices, your opinions, your comments, your questions, complaints, concerns, whatever. So the board's open. Meantime, I'm going to take a hit for everybody. I think the main thing is to make sure we go through a redress process. Is basically what I'm trying to put out tonight. We need to redress the problem. The problem is not just them. It's us too. We've been making mutual mistakes. And if we really want a mutual peace treaty, then we have to go about it in the right way. We have to, seek amnesty, forgiveness for our political sins. Say that again, brother.
No, that was just me. So I was looking at found some videos going through the birth certificate. So another thing that I was looking at about the certificate of live birth, the content is in the, if you understand the contract rule, the 4-square rule, the content is all within that square. And and when they authenticate the birth certificate, they only authenticating the seal and not the content.
Which is the history. The history attachment. That they
Right.
don't reveal. I know, I read all this.
So what I'm saying, we have to correct the record, right? And make sure that we attach our intent and purposes for the use of the name in any notice or warning or such violation associated with the fee schedule.
Good. You say this right now. What you talking about, what you talking to me about?
I can't hear anything.
Is the meeting over?
Oh my, how did that happen? I've been talking all this time muted, huh? How long have I been going, folks?
5, 7, 10 minutes.
About
Oh.
8 minutes.
My. Well, let me go over it real quick. We have evidence through the postal system that co-trustees sent instruments through the mail.
I've been,
We don't think it. Sit back thinking it. Analyze.
Each of them gave us receipts.
They should analyze.
One gave us the certificate of trust that formed the trust with names of parties and everything in there. The beneficiary being the one that was born, the new one. The informant being the one granting, because that is not a signature, that's an informant, that is not a signature. There are two down here denoted as signatures. One is a doctor and one is the registrar. And as signatures, they are as signed. They assigned themselves in trust. Okay, so this is the actual trust instrument. This is the trust certificate. On this one, Joyce is the second person named on it. Clearly the beneficiary, upper and lowercase. This one too. State of South Dakota, first name, second name, Joyce Ann Schmidt, all uppercase. Again, again, a beneficiary. So now we know the co-trustees as the doctor and the county registrar, and the co-beneficiaries of the instruments, that when the titles merge with the beneficiary, Joyce, it's supposed to be collapsed. Operation of law, folks. And as her life companion, her living blood trustee, I have a greater duty in all trust than anybody else. And I do step up to the plate. She is my queen. I am her king. And nobody comes against my queen for anything without me having my say in it.
so let me talk about do the doctrine of merger apply?
Yes. Yes. Body of one. You don't take, this is why a woman and a husband don't testify against each other in court, because they're a body of one. They are already merged. So by that alone, me being her trustee in that merger, I take over trustee of all other elements if I feel the need to. That's my capacity.
So we take an affidavit of marriage down there, and you can be deemed as the executor over the estate. And
Yep.
give them everything
By correcting the record.
By correcting the record and everything, and you can give them the fee schedule associated for any trespass that they do, right?
Correct. This is the way it operates. This is the way it's supposed to go. If you trespass it and violate, I'll be sure to put this fine, fee, and penalty on my invoice when I advance it or move it towards the judicial review for a review again.
Now, let me ask you, under the doctrine of reference of by corporation, could we now reference that in the will and deposit and make that a depository as an estate of the will?
Most
Well,
certainly, by reference, what they did again is the right to follow trust property when confused with other property. Now, it doesn't say who confused it. What we're doing is saying it's just confused and we need to correct the record. And in so doing, all we're doing is following the trust property that truly belongs to us. We're not trying to take anything that doesn't belong to us or anything. So in operation of those script notes, if there's truly a credit of $250,000 owed to us, even though we're not technically supposed to use military script, the only equitable remedy is to have credits on account. as opposed to money of account. And that's all we're doing. So even if the system changes, we still have credits called units. This is why when you look at an MCO, folks, look at an MCO or an MSO of like a motorbike, you know, like a little, like if you ever get like a moped or something like that, and instead of telling you motor vehicle, it's going to tell you unit, 1 unit. What they did was split titles and called it a motor vehicle. What's the split title on? It's either an automobile or a motor vehicle.
You know what's so funny, Keith? I was looking at the Bureau of Motor Vehicles. I mean, the Ohio Bureau of Motor Vehicles. And if you look at everything, instead of it saying the state of Ohio Bureau of Motor Vehicles, as in relation to the Ohio BMV, and then relation to the statute, it is say Bureau of Motor Vehicles. So those are 3 different positions. Those are 3 different names.
Yep.
So you don't even know until you register, it's done under the register. So all of that stuff is confusing. So I was just identifying to people, look at the language. If it's not saying the state of Ohio, it's not a state entity associated to the state of.
Yep,
so
exactly.
It's private, and then it went to rural motor vehicles, and then I'm like, okay, they dropped the Ohio.
HUD does that too. They do rural and urban development, housing and urban development. Well, what's rural development? Well, that's where we're going to develop urban develops. Well, so when you look at the laws, they got to condemn rural land, which is agricultural land. They got to condemn agricultural land, which is rural land, so they can create urban areas. Urban areas, not land. Because it's just, urban areas are just the premises on top of the land. It's the concrete slabs and everything above. Even if you dig a hole in the ground and build a little box, it's still just that and above. It's not the land itself. None of their laws can pertain to the land. The land shall not be sold forever, for it is mine, and ye are strangers and sojourners with me. And if you think he guards them little birds and doesn't guard you or his land, listen to Mother Nature once in a while. That's why we're supposed to step up as those lines. We're
The
supposed
only
to.
thing we purchasing is the commercial paper.
Yep.
That's it.
Anytime you write something down, it's because there's some kind of need for clarification. So when 2 people are sitting there signing back and forth of each other, they don't know each other's language and they're just trying to point to things and stuff. When it comes to having to write things down and conform to a language, it's because there needs to be an agreement. Otherwise, we can operate in agreement just by sign language, don't you think?
But can't we even disqualify because they use the translation? Legalese is like talking Japanese, Russian, and all of that, right? Because
Right.
the lawyers ain't nothing but really translators in a sense, as you look at it, because they talking a different language.
Right. It's political grammar. And that's why I say if we seek, if we just put out I put out a statement of separation, it's the same thing as an oath of amnesty or something like that, requesting forgiveness. Basically, it's just letting them know that you made a mistake in making political agreements that you never meant to. You can go ahead with your political body and stuff, but I just don't. You seem to have misinterpreted information that I've given you as if though I'm part of your political body, and I'm not. You know. And that's a good point to point out, because I don't understand your political language. I don't
So
understand
how
your
will we
beliefs.
do that? Will we do that in the newspaper or put it on or publish it on our internet site?
Yeah, I just do it on my internet site. And if need be, you just send everything to US Department of State. Let them know, here's the gig's up, I recognize that I'm not eligible for a social security number. I called the Treasury and requested to find out if there's any debts held against the name or number. And they told me, no, there's no debts, public or private. So I no longer owe the, obviously, according to your own statements, that I no longer owe a debt to the United States. So therefore I withdraw any kind of presumed allegiance that you thought I might have given, because I never did give it. My allegiance has always been to my Father which art in heaven. And a lot of this stuff, matter of fact, let me pull that up, because what we're talking about, oops, wrong one. What we're talking about is giving away information that we're not supposed to be giving away. So what I did was I wrote up a statement of separation. Okay. Statement of separation. I, formerly known as Keith Orland Minaj Conradi Little, and now known by Elohotep II Wipero, do hereby make the following statement of separation. Okay, they always want you to fill out this form or make a statement. I'm going to make a statement from now on. From employment of trade or business, otherwise known as performing the functions of public office within or without the Department of State of the United States, information agencies, and instrumental constructs. That's a qualifying statement right there. Notice it's all lowercase, concise English, information agencies and instrumental constructs. Knowing that every contract they put forth, it's a constructive contract that you're not qualified for yet until you sign it. And they're going to instrumentalize their agency and their threats and coercion against you to get you to sign it. As used herein, the term employment, because they hold threat of employment, you have to have a social security number in order to get a job. You have to have a driver's license. They import this stuff upon you in public education. It's induced. They tell you all kinds of advertisements on TV about cars and everything. Yeah, you need a driver's license, this and that. Don't drink and drive. Yet without ever once defining drive as opposed to travel. As used here in the term employment includes all periods of assignment. Remember that number was assigned. Or detail, the information you gave them after above and beyond any assignment is the details of information that you gave in the offer and acceptance of contract. Offer and acceptance in formation of contract, as well as any periods, temporary, part-time, or intermittent employment therein. And the term separation includes any suspension for any period in excess of 30 days, retirement from commercial activities, entry into disability or pension programs, of which benefits are guaranteed for prior consideration, whether duly paid or as contributions. I have in my possession only documents, instruments, which I am allowed through prior consideration for actual benefit by and through equal rights among the laws. I shall not publish nor reveal to any person any classified or administratively controlled information of which I have knowledge or any other information transmitted to myself in confidence in the course of any performance, contracts, leases, bids, awards, rewards, etc., except as may be authorized by the officials of the employing department or agency empowered and conferred by federal executive order granting permission to disclose such information with full indemnification. That, remember, that federal executive order is at 48 CFR 52.212-5, contract terms and conditions required to implement executive orders or statutes, commercial item. I hereby advise all principals, agents, actors, participants, performers, interlopers, interveners, officious, intermeddlers, etc., to heed the criminal penalties related to United States government records, information, and the use thereof as a matter of national importance. It's not important to me. If you violate their laws, they're going to penalize you. I have no military code. I have no penal codes. I have no criminal codes. I prefer not to operate in commerce and therefore quit signing things 6 years ago. Closed all bank accounts, quit applying for employment, no longer have a job. Not going to do it. I stand by my word. Violations often committed, but not limited to, by officials, officers of the court, and participating agents not learned in law. 18 U.S. Code sections as follow. 641, public money, property records. Ain't my money, ain't my records. Keep out of my life. 793, gathering, transmitting, or losing defense information. If it's my private information, then how is it your defense information? Oh, that's right. The term defense. The root word being fend. I will fend for myself. You have no right to any defense of myself. 794, gathering or delivering information to aid foreign government. So if you're posing as a state attorney general and you're issuing claims under a local district attorney who's made a false claim of a personal jurisdiction that he can't possibly obtain without first asking permission from the United States under the 14th Amendment to acquire personal jurisdiction of that dual citizen that has been assigned the number. I find this stuff very, very questionable. 798, disclosure of classified information. Would you agree the Social Security number is classified information? Yes. Then who are you to request classified information without requesting permission from the United States first as to whether you can have that classified information? Have you asked them? Because I'm not qualified to give it out. I haven't filled out a form 312 or a form 189 or a form 189A. I haven't filled out those national papers as someone that owes allegiance to the United States and needs to fill out those forms. 952, diplomatic codes and correspondence. That's what we talked about earlier. 22 USC, or 22 CFR 93.1 and 93.2. Diplomatic channels of notice and notice of suit. 18 USC 1001, statements or entries in generally. We also talked about that, misinformation. If you give them information that is to correct the record and they don't abide by that, they are violating that, and that brings in espionage. They are willingly and intentfully bringing harm to another man that does in fact have conferred and by admittance assigned a protection of a United States person, an internationally protected person, by the assignment of a Social Security number. We are in fact allowed to give that number in lieu of the name and address. concealment, removal, or mutilation generally. Mutilation generally is ruining the good name by requiring you to give a name and address. I'm not required. I can give you a number. Well, what's the number? It has to be a social security number, but I can only give it to you if you ask permission from the United States, showing that you have are qualified to receive that number. Otherwise, you have no jurisdiction to even ask. Period. Includes, but not limited to, 42 U.S. Code, which is the public health and welfare, violation of specific sections, violation of sections generally, one of my favorite terms, communication of restricted data. Again, just asking for it is a violation if you are not qualified to ask for it to begin with. Receipt of restricted data is the same. So when the attorney gets the information from the nice policy officer that didn't have the qualification to ask for that information, but demanded it and coerced and threatened you to give it to him, now turns around and pushes a suit in a court without again notifying the United States, because it's a court of the United States, I find it inconsistent that anybody, again, anybody that has any amount of law degree, 8 years, 12 years, I don't care if you've been studying it all your life, this is something that should be known in every law community. This should be one of the most preemptive things in every attorney's license, lawyer's license, which only happens to be a certificate that hangs on a wall. Certification is false. That lawyer doesn't know what he's talking about, and I can prove it. Refuse to follow the law again. Refuse to bow down when I tell you you have no authority again. And I'll show you immediately where you get your damn authority under grant. Without requirement for licensing. Receipt of restricted, tampering with restricted data. Disclosure of restricted data. These violations lay wide the civil process of 42 U.S. Code 1983, civil action for deprivation of rights. Merely for asking and passing it around. Once I say no, my yea is my yea and my nay is my nay. Your probate courts have no jurisdiction over the living will of a man. I said, do not do it again. You have no authority from the one that is supposed to give you consent of passing the information. I no longer wish for you to pass it. I gave it in error. I asked for forgiveness. I made political and grammatical mistakes, period. These violations lay wide the civil process of civil action for deprivation of rights, 50 U.S. Code 783, receipt of or attempt to receive by foreign agent or other member of communist organization classified information. Now, I didn't put it in here, but it still sits on the congressional record of 1950, the 81st Congress, wherein the Congress investigated the Lawyers Guild and determined that foreign bar agents are, in fact, by definition, communists. This is still on the record, has not been removed. And no one has stepped up and rebutted it. I used it in my last case. No one rebutted it. I state it repeatedly. It sits on my Facebook page and remains there. And nobody's rebutted it. Meaning it still stands to this day. limitation period. In regards to employees, principals, agents, actors, performers, participants, etc., these restrictions are consistent with and do not supersede, conflict with, or otherwise alter the obligation, rights, or liabilities of said persons created by Executive Order 12356. A debt previously contracted. Section 7211 of Title V of the U.S. Code governing disclosure to Congress. Section 1034 of Title 10 of the U.S. Code, as amended by the Military Whistleblower Act, governing disclosure of illegality, waste, fraud, and abuse of public health or safety threats. If you're going to be demanding I give out public health information or health information and make it public, I take that as a threat. I take it as a deep threat. None of your business. He who is whole is not in need of a physician. So why are you requesting medical health information, private information at that? The Intelligence Identity Protection Act of 1982, which is 50 U.S. Code 421, and essential acts after that. You'll see 421, 422, 423 sequentials. Governing disclosures that could expose confidential government agents. Now, I may not be an agent, but I guarantee you, if you don't do your job correctly, and I'm merely trying to correct the record, and you, in your job, expose a confidential government agent, you can be in a lot of trouble. You could be considered committing espionage. Now, I don't want to be convicted of that. So I have to deny it all and just not give that information out anymore because it is of national importance. It's what all of their insurance programs run on, is health information. Are you healthy? None of your business. You see, I'm whole, right? If I'm a whole, and scripture says, he who is whole is not in need of a physician, then why are you asking? Do you have a medical license? No, you've got a badge? Well, that's a commercial license, but you don't have a legal license either? Let me tell you what, that badge is a debt previously contracted, not necessarily a license. And the statutes that protect against disclosures that may compromise the national security, including but not limited to the sections I mentioned above. And again, it's the statutes that protect against disclosures. And if you know the components of a contract, it maintains privacy. And that's what it's privacy. And it's the statutes, contract terms and conditions required to implement statutes, are protecting against those privacy disclosures. Period. The definitions, requirements, obligations, rights, sanctions, and liabilities created by said executive order and listed statutes. These are written listing contracts. Written listing contracts. They are listed in a code, and they are listed by code numbers. Not limited to, or statutes are incorporated into this agreement and are controlling. I reaffirm that the provisions of the espionage laws have been made available to said principals, agents, actors, performers, participants, etc. I've made it available. I reaffirm that here now. I have returned all necessary classification information to proper authorities. that I will not transmit, communicate, convey classified information to any unauthorized person, organizations, that I will promptly report to the Federal Bureau of Investigations any attempt by unauthorized persons to solicit classified information with or without a security debriefing. So when you come at me, you better make sure you've gone through the administrative process of making a judicial review before you try to even communicate with me. Period. I am aware that Title 18 of the U.S. Code Section 1001 provides criminal penalties for knowingly and willingly falsifying or concealing material facts in statement or document submitted to any agency of the United States government concerning a matter under its jurisdiction. I have to give you evidence of material fact that I knowingly no longer owe a debt to the United States and am not subject to be eligible for a Social Security number because it is not needed, because no such debt exists. You have been given knowledge. Please act accordingly. I don't know what you guys think, but I think that's very succinct. And I don't think I misportrayed anything in that. Yeah, I got a little passionate again, but I'm telling you, I ain't putting up with nobody's bullshit anymore. I question everybody and everything for all reasons. I can handle the abuse. Tired of not being able to help people that can't. Tired of not being able to step up and make my word their word. I'm tired of seeing people stand there and watch somebody else with their knee on somebody's neck with a fucking video camera in their hands instead of dragging them off. I'll not put up with it anymore. We all deserve peace by any means necessary. So anyway, I'm done. I hope everybody gets this. I don't know how long we've been on.
Thanks, Malika.
Almost 2-3 hours. Yes, thanks, Malika. Everybody throw your hands up and say hallelujah. Yeah. We are winning.
Yes,
We are winning because of people like Malika, King L. Bay, Russ Combs, Lord Messiah, Doug, Venus Johnson, call-in user 1, Marvin, Christopher, KNF. We're winning because all people that are listening and then just putting it out there, sharing the same thing without having to charge another person for anything. So God bless y'all. I'm going to get this downloaded and post it. Let me see here. Yeah, people are afraid. And yes, I'll record it. It is recorded and I'll post it. And sorry about babbling for about 8 minutes. I didn't realize I was muted. So anybody that watches it, there's going to be about 8 minutes of muted me showing things on the video and nobody knowing what I'm saying. So I just reiterated and restated it. All right. So in the meantime, again, I'm going to post my PayPal link just like normal, along with all my other forums. I want you to share this information, the videos, the public domain information that I'm going over with you. I'll post those links. I'll go back and grab them, post them when I post the Zoom. So they'll be there too. Post everything, share everything, but do so freely. So when you hit that PayPal link, share some love with me freely. Whatever you can help, every $10, $20 is always helpful. But also remember, that's not the important part. The most important part, as we're trying to escape this commercial realm, is to share the knowledge and experience it for yourself so that one day you will be able to share the wisdom. In that, God bless you all. Have a good
Thank you
night.
so much, brother.